My lady, I'm Mr. Hogan, senior counsel.
Can you just wait a moment, please, Mr. Hogan? I'll let you know when I'm ready. Thank you. Yes, Mr. Hogan.
This is my learned friend, Mr. Shahid, also for the appellant, and for the respondent to my learned friends, Mr. Andrews and Ms. Shah, senior and junior counsel, respectively. Would it assist the court to hear the facts of this appeal?
Yes, a very brief summary, please. I know that time is not particularly with us this afternoon, so a very brief summary, yes, thank you.
Mildred Smart was married to Sam Smart. Over several years, it's common ground that he was abusive to her in several ways. And then on the evening of the April 12th, 2013, Sam launched into an attack on Mildred, who, after she'd been knocked into a stupor, reached for her scissors from her sewing box and delivered a fatal blow.
I have read the facts, Mr. Hogan. I asked for a summary of the facts, but I think you redacted it in a way that might give an impression that the sewing box, she reached for her scissors out of her sewing box. I think there was some movement in the house to actually fetch those scissors.
Yeah.
Thank you. Well, I'm just advising you that when you do provide a summary, you redact the facts, that you do it in a way that doesn't mislead the court.
Okay, thank you. Would it assist the court to hear the grounds for appeal?
Yes, it would indeed.
Firstly, that the learned judge, Judge N. Correct, misdirected the jury on the law. The Coroners and Justice Act, sections 54 to 56, and he said that the defence of fear required evidence of violence in danger of life and nothing short of it, which is section 54, subsection 3, and that loss of self-control required a reflexive response to the qualifying trigger. The second ground is that the judge misdirected the jury when he said that fear must be objectively construed and judged on what circumstances would place a reasonable person in fear, not what might or would place a defendant in fear. And he said he did not think much of this battered woman syndrome thing.
Indeed.
May I begin my submission?
Yes.
In our view, this appeal turns on the proper interpretation of sections 54 and 55 of the 2009 Coroners and Justice Act. Our bundle should be available to you.
Yes, where is the bundle?
On the spine is written the Crown Against Smart.
Thank
Appellant.
you. And you're going to take me through this?
Yes.
Thank you. Can you just give me a moment, please, for me to just briefly have a look at it? Yes, thank you, Mr. Hogan.
The relevant sections of the Act are found under tab 2 and pages 6 and 7. We're not proposing a creative interpretation of this Act. It is very clear. There are a very small number of cases which have added a slight bit of clarity, but the Act itself is drafted in a way which allows little scope for deviation from it. We submit that the learned judge followed the Act correctly in that he admitted the Section 54 defence of loss of control to the jury, but his accompanying direction was misleading because it restricted the jury to considering only one of the 3 possible qualifying triggers under Section 55. Section 55 provides 3 routes to a qualifying trigger. The first is under subsection 3, which is where the defendant's loss of self-control was attributable to the defendant's fear of serious violence from the victim against the defendant or another identified person. Or subsection 4, which applies if the defendant's loss of self-control was attributable to a thing or things done or said or both, which A, constituted circumstances of an extremely grave character.
Yes, thank you. I can read the sections. Can you just move on with your argument?
Thank you, ma'am. Crucially, well, the judge's direction spoke only in terms of the subsection 3 qualifying trigger, fear of serious violence. If you'd like to turn to the direction again, my lady, it is back a tab 1, and it's page 5.
Yes, I have it.
He said the defence required evidence of violence endangering life and nothing short of it. And that takes no account of the subsection 4 defence, which is circumstances of an extremely grave character.
Are you going to address me on the required evidence of violence endangering life and nothing short of it?
No, my lady, because in our view, this appeal rests on that Mrs. Smart was subject to circumstances of extremely grave character, and she would have felt seriously wronged and justifiably so.
And why has your team decided on this, to adopt this strategy?
Because
you're putting all your eggs in one basket, are you not?
the subsection 5 defence, the subsection 5 qualifying trigger is a combination of fear of serious violence and of circumstances of extremely grave character.
All right.
In fact,
you may proceed, but please can I make it clear that I will be expecting some argument on the point of the learned judge's misdirection in the grounds on evidence of violence endangering life and nothing short of it. I will be expecting some development at that point.
Can we address that point first?
Maybe you could ask your junior, if you're not ready to proceed with that at this point, you continue with your argument
I can
and
address that.
set it out.
I can address that now, my lady.
Well, it's a matter for you, how you want to do that. I don't want to take you off course.
I'll address that now. Firstly, the subsection 3 requires only that the defendant fear serious violence. There's no requirement for life-threatening violence, so the direction was flawed in that sense. Indeed, if she had feared life-threatening violence, she would have been justified in using deadly force in response under the self-defence defence.
Yes, we're not dealing with that, but I think I do want to hear you develop that a little bit more. And you have said, quite rightly, that the statute uses these precise terms of serious violence. And I would have expected to have heard further on that point.
Serious, well, it's analogous to grievous bodily harm. The grievous bodily harm is really serious harm, that's how it's interpreted by the courts generally, and there's no requirement for life-threatening harm. And Mrs. Smart had suffered really serious harm.
Are you going to develop the evidence as to what the serious harm is? Are you going to explore that?
Yes, my lady.
Yes, all right.
Well, I was...
Continue with where you had got to before I interrupted it. Thank you.
back to the subsection 4,
yes.
Qualifying trigger. Thank you, lady. Let me just consult my notes for 1 minute. We can look at the evidence for the subsection 4 defence, circumstances of extremely grave character. She was beaten and raped by her husband in the years leading up to his death, and then at that point she was very seriously hurt by him, and he also threatened to kill her if she left him. In our submission, a serious beating and a threat to murder someone do indeed constitute circumstances of an extremely grave character, and the defendant would have been justified in feeling she was wrong. The justified part of that statute is an objective test, and we have no trouble believing that any reasonable person, embodied by a jury, would find that Mrs. Smart was justified in feeling seriously wronged by her husband's actions that evening.
Can I stop you here? This is a case where the facts point to a woman who undoubtedly has experienced domestic violence and is undoubtedly a battered woman. You are arguing in this court that you are not going to rely on the ground of 55.3, and you are going to concentrate on the ground of circumstances of extremely grave character. Are you going to address the court? Are you going to address this court at all on the fear aspect?
I had one point to make on that point, which was that she had said she was going to leave him, and he had promised to murder her if she was to leave him. And if she were resolved in leaving him, then that's surely a threat for her to be murdered, which in our view easily meets the requirements in subsection.
Yes. Can I ask you on this? Since there is a time lapse between the last act of violence by the deceased and a considerable lapse of time, and taking into account, of course, that the proximity in time between the last act and the retaliatory act, if I might put it like that, is now no longer a legal requirement, it is nevertheless something that must be looked at, given that the statute tries to make a distinction between a considered desire for revenge in such cases. So my question to you, I'm afraid, returns us to the fear element. It seems to me that is important for you to try and make submissions on in terms of the fear of the defendant, of the appellant in this case.
It might.
Because there is a considerable lapse of time. So how am I going to treat that if you rely on this other limb of the act, which is circumstances of grave character and loss of control? How relevant or how important is fear to that? Or is it excluded? This is my difficulty. A fear defence comes under the other limb. This defence that you are saying that can be advanced is a matter that doesn't rely on fear. So my question again is, how do you deal with the time lapse?
The time lapse, there are no cases specifically to do with time lapse since the new Act has been introduced. I was going to refer the court to the Crown against Al-Awali, which is a Court of Appeal case.
I'm sure that would be useful, thank you.
That is found under tab 5 of the bundle on page 65, section 32. This was good law until the new Act was introduced. Here it established that the delay between the provocation and response was not fatal to the defence of provocation. We submit that it essentially dispensed with the requirement that...
I'm with you on that, but the whole basis for Lord Taylor making that assertion was on the basis that this woman was indeed a battered woman. And I'm wondering, I don't know how, you have to tell me on this, I'm wondering how to approach the case, as you have narrowed it now, to the limb of circumstances, extremely grave circumstances, which doesn't seem to align with the fear limb, and I'm wondering how I'm to approach this time gap between the last act of violence and the act that caused the death. You now rely on Al-Awali, and I agree that is still good law, but Lord Taylor actually made that judgment in a context of saying this woman is a battered woman. I mean, are you removing that battered woman and the fear element from your submissions? I mean, there is a way in which one can look at these together as well. I don't know whether
Yes, that's subsection 5. Which, on the point of delay, she was beaten and was essentially unconscious for 2 hours, at which point she acted. Upon regaining her senses, she acted immediately. And the 2 hours may as well not have happened as far as she was concerned.
I see, thank you.
I had some further points to make regarding, well, my learned friends will no doubt make a great deal of Mrs. Smart's words to her counsellor and hold them up as proof that she acted in cold blood with a considered desire for revenge. She said to her counsellor, "I will kill him," or words to that effect, "I will kill him if he beats me again." We submit that Mrs. Smart knew she had already been pushed so far that she could well lose control if she were attacked in that way again. There's nothing in her character to suggest that is bent on violence. She'd been repeatedly beaten, she'd been raped and humiliated at the hands of her husband, and nobody should be expected to tolerate this kind of treatment. And this new defence, loss of control, recognises this and provides a partial justification for killing in these circumstances. If the appellant, Mrs. Smart, had acted with a considered desire for revenge, her methods were very unusual. She didn't go to a gun cabinet or a kitchen knife, she went to a sewing box and used a pair of scissors. And it was only by chance the wound she inflicted on the deceased was fatal. It was only a nick, according to the facts.
Yes, I'm with you. I'm with you on that, except for your submission that this limb of the Act was designed to deal with the circumstances in this case. As far as I understand this limb of the Act, it was designed specifically to restrict the panoply of cases where largely men had brought, had made out that in fact, thank you. I'm going to just continue with the point, if I may, although I recognise time is up. The purpose of this limb of the Act was designed to limit men who said that their wives were having an affair, men who brought a whole panoply of spurious reasons and circumstances, and evaded murder convictions and succeeded with provocation. I was not under the impression it was the purpose of Parliament or the intention of this limb in any way to have assisted a battered woman such as the appellant in this case. I understood, and please, I think you need to reply to this. I have interrupted you for a lot of your submissions this afternoon. I understood the first limb of the new Act was designed specifically to deal with the appellant, and yet you have chosen in your argument to say that you would prefer to develop your submissions to the court on the second limb.
In our view, the limbs...
Please take your time to reply, because it's something that I'm rather stuck on, and so if you can help me at all with this.
The section of the Act, 55, it only branches into these three limbs at this point. The rest of the Act is common to any qualifying trigger. I'm not aware of any intention that one of these be directed at women in particular.
So it's a matter of construction. You're advising on this.
Yes.
You may well be right.
Yes,
the opportunity to consider this a bit later.
A big criticism, I think, was that there was a requirement, which was partially dealt with in Al-Awali, there was a requirement for suddenness. Yes. And that was because women suffering battered women syndrome didn't tend to react quickly in anger. They tend to have more of a slow burn reaction. And that element of the Act, I believe, is directed in redressing that problem with the old law. But
did this appellant have a slow burn?
Yes, over the years, you could argue that over the years of abuse, 3 years, and evidence of that is seen in her interview with the counsellor.
Thank you very much, Mr. Hogan. It is uncharted territory, and we're all feeling our way, as it were, with the Act.
Thank you very much. Mr. Andrews is next for the respondent.
May it please my lady, I am Raiff Andrews, the senior counsel for the respondent, accompanied by Nasreen Shah, the junior counsel for the respondent, and I will begin by submitting arguments for the respondent based on the first round.
Could you just give me a moment to refer to your bundle?
Absolutely.
And your skeleton argument?
My skeleton argument is found on yellow tabs.
If we had less absolute, we could get along a lot better. Thank you, Mr. Andrews. Yes, I have it. Thank you.
May I proceed?
Yes, thank you.
I'm obliged. I will first submit that there was not a sufficient qualifying trigger for loss of self-control. My second submission will be based on the argument that Mildred Smart's actions were fueled by her desire for revenge. If it pleases the court, I would like to offer my first submission.
Yes, thank you.
I am obliged, my lady, it can be strongly argued that the criteria for a qualifying trigger are not met. The first criteria for the qualifying trigger is defined by Section 55, subsection 3 of the Coroners and Justice Act 2009, which can be found on green tab 1 in the first highlight in green.
Yes, thank you.
May I proceed?
Yes, thank you.
Subsection 55, Section 55, subsection 3 of the Coroners and Justice Act 2009 states, this subsection applies if D's loss of self-control was attributable to D's fear of serious violence from V against D or another identified person. My lady, it is fair to say that Mildred Smart could reasonably fear serious violence from Sam Smart, based on the past history, but she could not fear this as an imminent danger, as Sam Smart was passed out due to an alcohol-induced intoxication. Mildred Smart had ample time to leave the house and go to a place of safety, such as a police station or a woman's shelter, where she could have averted violence from her husband indefinitely. Instead, she made the conscious decision to arm herself and create a further situation of danger. Thus, it can be strongly argued that the criteria for a qualifying trigger were not met, as there was no imminent danger of fear due to Sam Smart's inhibited state.
We are in danger, are we not, of going over the facts and the trial itself. What do you say on what you have already put before this court as to the first ground of appeal and the phrase that the learned judge, Judge Incorrect, uses when he says that loss of self-control required a reflexive response to the qualifying trigger? Or are you coming on to that?
I do cover that in my section on fear, so
All right.
I do cover that.
So we are leading up to that.
Yes, madam.
Thank you.
My lady, it can be strongly argued that the second criteria for a qualifying trigger is not met. The second criteria is defined by section 55, subsection 4, paragraphs A and B of the Coroners and Justice Act 2009, which can be found on green tab 1 as the second highlighting ring. Does my lady have some?
Yes, thank you.
Would my lady like me to read it?
Yes.
Subsection 55, section 55, subsection 4, paragraphs A and B of the Coroners and Justice Act 2009 state: the subsection applies if D's loss of self-control was attributable to a thing or things done or said, or both, which A, constituted circumstances of an extremely grave character, and B, caused D to have a justifiable sense of being seriously wronged. My lady, yes, this situation is of course extremely grave in its character. However, it is not reasonable to suggest that Mildred Smart should have taken the law into her own hands, as it was completely unnecessary in this situation to do so.
Well,
My lady,
can I just stop you there, please?
Yes.
Mr. Andrews.
yes, ma'am.
You've contradicted yourself, have you not? Am I required to do any more than to be satisfied that it constituted circumstances of an extremely grave character? You have said that there were circumstances of extremely grave character, but they were not reasonable.
Well, I'm saying that actually, I'm saying as in the situation as a whole is extremely grave. In the past history between them is of course abnormal, and
I think you better just stop there and reconsider what you are saying to this court.
yes, madam.
And take a few seconds. Perhaps we'll come back to that point in a minute.
Yes, madam.
If you'd like just.
May I just summarise it for you?
Yes.
Basically, the underlying argument I have in this point is that the wider implications of allowing someone to take the law into their own hands in this way do not correlate with the purpose of the law, and that is to lay down a framework of order. And I believe if Mildred Smart's actions contradict that concept.
Yes. And how, again, can I ask the question again in a different way? How is this, these submissions you are making to the court going to assist me in assessing to what degree the first ground of appeal is met or not? Are you going to turn to the wording of the judge and his summing up to the jury?
Yes, my lady, I am casting doubt as to whether really these criteria that the judge mentions are indeed fulfilled. As you will see when if I may proceed. My lady, would you like me to outline the inconsistencies with the defence of self-defence in the context at hand?
Well, I'm not sure where it's going. I mean, your argument is surely for the respondent, is it not? It's your argument that the judge erred, but not sufficiently, or the judge didn't err. Is this where this is going?
May you elaborate, my lady?
I don't think I can without putting any more words into your mouth. But I would like you to address the two grounds of appeal, and presumably you are going to...
They are indeed addressed, my lady.
There, all right.
My lady, I would now like to consider the inconsistencies with the defence of self-defence in the context at hand. Lady Justice Rafferty in, I believe, Crown and Doors 2013, England and Wales Court of Appeal, Criminal Division, page 322.
And where is that in the Bible?
Pink, tab 3, highlighted in green.
Pink, yes, how appropriate. I'm sure Lady Justice Rafferty would be thrilled with the pink on 3. Thank you. Yes.
I am satisfied, so that I am sure that no jury could reasonably conclude that a reasonably tolerant and restrained man in the defendant's circumstances have reacted in a similar way. Does my lady have sight of this quote?
No, I don't. I've lost the pink tab now. So it's got, it looks like 3 on one side this boundaries, 8 on the other. But anyway, refer me to the case now, will you? Otherwise I'll have to ask my clerk to help me with.
Is Crown and Doors 2013.
Yes. If you have a page number, that might be more helpful. I've got 1 to 16 here.
I do not, my lady.
You don't. But it's somewhere on the pink tab.
It's on the page of the pink tab is on.
It's on the page of the pink tab. It's not what I've got highlighted. Would you like to start with how it starts?
Yes, sure. I am satisfied, so that I'm sure.
No, I don't have I am satisfied, but tell me
Okay.
slowly. I am satisfied, yes.
I am satisfied, so that I am sure that no jury could reasonably conclude that a reasonably tolerant and restrained man in the defendant's circumstances might have reacted in a similar way.
Yes. And how will that help us?
Thus it is clear that Mildred's reaction was not of one that someone with a normal degree of tolerance and self-restraint would have made. My lady, may I now refer you to the page you are on, which is pink tab 3, highlighted green.
Yes.
And this is Crown and Doors 2013,
Yes.
England and Wales.
Yes.
Court of Appeal, Criminal Division, page 322. Would my lady benefit from a brief summary of the facts of this
No,
case?
thank you.
I'm obliged. My lady, Lord Judge, Chief Justice, in this case stated, but even if the defendant may have lost his self-control, provided his violent response in self-defense was not unreasonable in the circumstances, he would have been entitled to rely on self-defense as a complete defense. My lady, it is clear that in this case, Mildred Smart did act unreasonably, and thus the self-defense defense is unavailable.
It's not the basis of the case, is it?
My lady, I was merely negating the argument of my learned friend, Mr. Hogan. My lady, I would now like to offer my second submission, and this is that Mildred Smart's actions were fueled by the desire for revenge. My lady, it can be strongly argued that the time period after awaking from the daze that had been induced by the violence she had suffered under the treatment of Sam Smart, and then going about the events that led up to the stabbing of Sam Smart with the scissors, was sufficient to gather her sense of logic and reason, and thus she did not act within the loss of self-control. My lady, I would like to refer you again to the case of Crown and Darren Jewell, 2014, England and Wales, Court of Appeal, Criminal Division, page 414, found on yellow tab 4 in green highlight.
Thank you.
Does my lady have sight? I'm obliged. Would my lady benefit from a brief summary of the facts of this case?
No, I'm very familiar with the case.
In this case, the defendant had been subject to intimidation for 2 weeks. Now, Lady Justice Rafferty stated the defendant had 12 hours in which he was able to reflect and react. My lady, although in this case the time period was significantly longer, by 10 hours, it could be strongly argued that the same principle applies to the current context. The significance of this in the current context is that it highlights the lack of a qualifying trigger for loss of self-control. My lady, if you allow me to elaborate on this.
Before you do so, it would be correct, would it not, to say that the circumstances of this case were quite different. The circumstances of a woman trapped in a house where there was a history of battering, that this was between 2 men, totally outside the domestic context, where there was a gap of 12 hours, and in the case that we have before us, the gap between the last act and the act which caused the death of the deceased was 2 hours.
Yes, my lady, I am aware of this fact, but I do feel that the element of pressure and of psychological trauma is relevant to both cases. And that really is the basis of what I'm saying here. If I may elaborate on this, Melanie, maybe it will...
So are you going to then suggest that the psychological trauma of women in a situation potentially of being a battered woman and with psychological and behavioural characteristics is similar to the situation in the case that you just cited, the psychological situation?
I do not focus on the subject
because
of...
I would want further evidence from expert, perhaps opinion reports on how the two psychological or behavioural responses are so similar, if that's your argument.
My argument is more focused on the fact that she actually did have time to reflect and gather her senses, despite the past events that have taken place that are outlined in the facts.
Isn't the point though about the considered desire for revenge?
Yes, which I do.
Yes.
This is relevant, so I come on to it. My lady, Mildred Smart had time to reflect and gather her senses. This is shown by the facts. She went downstairs, which, if disorientated, can be a tremendous task. She poured a glass of whiskey. She had time. She recalled that she had scissors in the embroidery box, and then she was able to go upstairs and stab Sam Smart. Now, thus it is evident that she was in full control of both her mental and physical senses. Thus, her actions do not constitute a loss of self-control. So with this in mind, the question becomes, if she was able to think clearly, why did she not leave to go to a place of safety? My lady, I feel the answer is simple, and that is revenge. Revenge for how her husband had treated her in the past. My lady, I'd like to refer you to again to the case of Crown and Dawes, 2013, England and Wales Court of Appeal, Criminal Division, page 322, which can be found on blue tab 5, highlighted in green.
I would, before you do that, like to return. I'm hoping at some point you are going to, with your submissions, alight on the two grounds of the appeal, and I am hopeful that you will deal particularly with the last line of the first ground, and that loss of self-control required a reflexive response to the qualifying trigger. You've said a lot about the time that's presumably you're saying, I think, if I can take from what you're saying, impliedly you are saying that there wasn't a reflexive response to the trigger because there was a time lapse. So I need to hear it from your lips. It's your submission, not mine. That's what if that's where this is leading. And in fact, what the judge said was in line with the statute, or if it wasn't quite in line, then it wasn't sufficiently out of line to render this conviction a miscarriage of justice. Can you help me with, are you going to take me to there? I feel we're going there.
Yes, my lady, I am.
Thank you.
If I may quote Lord Judge Chief Justice, who stated, the judge directed that they should consider the things said or done both on the time of day and the instant and in the period beforehand. My lady, I think this is relevant when considering Mildred Smart's state of mind for her husband, Sam Smart, both before and after the event. I feel that she has had this malicious state of mind before and after the event. As the facts show, we have from the counsellor and then in a police interview afterwards where she declaratively states she felt her husband deserved it. I quote, he beat me, he abused me, he raped me, I hated him for that. And I feel that this really is the motive for the murder. With regards to the reflexive response, as I have outlined, the time lapse, I feel, was ample time for her to gather her senses, and that with regards to the qualifying triggers, the respondent would like to submit that these are not fulfilled due to her motive for revenge, which is, if I may very quickly, my lady, in the interest of time, reference section 54.4 of the Coroners and Justice Act, which can be found on the other tab 6. I'm going to stop you, Mr. Anderson. I'm going to ask you if you can just sum up in one sentence. I feel that some of your submission has been like a retrial of the appellant. If you could summarise in one sentence what you say to the case for the appellant that we have heard in part with regard to the two grounds. How would you respond?
I will put in essence, did Judge N correct, misdirect the jury on the law on those 2 points? I won't read it out again, you have it before you. That's what I just need to hear if you could just in sum.
With regards to the reflexive response, I believe it was not appropriate, and for the reasons I've outlined so far, with regards to the qualifying triggers, I do not believe that they were met. The qualifying triggers were not fulfilled for a loss of self-control.
So, and the judge, did he misdirect the jury on the second point that we're raising?
Yes, my lady. No, sorry, he did not misdirect, because he... Sorry, my lady, may
yes,
I?
Please take a second. This is very important, and I need to be clear on what you as senior counsel are saying to this court.
My lady, thank you.
Please take a minute. When you're ready.
I believe that he did misdirect the jury in saying this, because he says that a loss of self-control required a reflexive response to a qualifying trigger. And in this sense, there was not a the requirements for a loss of self-control were not met, and thus.
Yes, well, perhaps your junior counsel will rehabilitate your argument
Yes.
when
Yes,
she
ma'am.
has the opportunity. Thank you very much, Mr. Andrew.
Thank you, my lady.
Thank you, Mr. Shahid.
May it please your ladyship, my name is Mr. Mohamed Shahid and I appear as junior counsel representing the appellant. My lady, are you familiar with the grounds of appeal? Are you familiar with the ground of appeal?
Yes, I'm familiar with the ground of appeal. I'm hoping that you're familiar with the ground of appeal.
My lady, I shall tackle the second ground of appeal under the following points. A. Taking into account the abuse and the threats, the fear that the defendant felt would have in fact placed a reasonable person in fear as well, hence highlighting the fear aspect that my senior colleague is referring to. Secondly, due to the treatment she suffered at the time of the incident, the defendant was suffering from an abnormality of mental functioning. And finally, battered women syndrome is a legally recognized cause for persons suffering from diminished responsibility in the English courts. If my lady has no questions, I shall proceed with the first point of my submission. Mr. Lawyer. Taking into account the abuse and the threats, the fear that the defendant felt would have in fact placed the reasonable person in fear as well. I refer my lady to the case of Crown against C, ex parte Janet Catherine, 2003, England and Wales Court of Appeal, Criminal Division, page 415. Found in the bundle of authority on Red Tab 7, page 76. My lady have sight?
Yes, thank you.
Does my lady require a brief summary of the facts of the case?
Yes, please.
After the appellant told her jealous, controlling boyfriend that she wanted to leave him due to him taking control of her money, isolating her from her friends and family, and increasing the unwanted and unpleasant sexual acts in the relationship, the deceased threatened to kill the appellant and also kill her 4-year-old daughter as well. Due to the threats, the appellant killed her abuser with an axe. She was found guilty of manslaughter on the grounds of provocation, not murder. My lady, even though this case may be distinguished from the case at hand, due to the fact that Mrs. Smart had no children, the rest of the case is quite similar to Mrs. Smart's case. She was also isolated from her friend Bill and threatened with further physical abuse and murder if she defied the deceased. My lady, I quote the judgment of the trial judge, Mr. Justice Elias. I quote, "Bearing all these matters in mind, we have come to the conclusion that this sentence was, in all the circumstances, excessive. These were terrifying threats. The jury's verdict shows that it accepted that they were taken seriously by the appellant. They were made by a man determined to dominate and control her life. They created fear for the safety of her daughter. My lady, I respectfully submit that this reflects that the fear that Mrs. Smart felt would have, in fact, placed the reasonable person in fear as well. Note from the fact that she also blacked out for 2 hours.
Can I just stop you in a minute? Fear placed a reasonable person in fear. Is the test for this court a reasonable person, or is it a reasonable battered woman?
I'm tackling the question that it was a reasonable person, which was what the judge previously stated in the previous case.
Before the present act and before the development of an understanding, to the extent that we have one today in 2014 on battered women syndrome. Your case refers to the state of play, if you will, in 2003.
Indeed.
Yes. So you still stand by that you're relying on that case, and the test views fear placing a reasonable person rather than a reasonable battered woman in fear.
My lady, I shall tackle the fear of the battered women later on in my submissions. Does my lady have any more questions?
No.
My lady, I shall proceed with the second point of my submission. Due to the treatment she suffered at the time of the incident, the defendant was suffering from an abnormality of mental functioning. My authority being the Coroners and Justice Act 2009, Section 52, subsection 1, which refers to the Homicide Act 1957, Section 2, subsection 1, paragraph B, and paragraph 1A, found on Purple Tab 6, page 70.
Yes, thank you.
Does my lady have sight? If stated, a person, D, who kills or is party of the killing of another is not to be convicted of murder. If D is suffering from an abnormality of mental functioning, which substantially impaired D's ability to do one or more of the things mentioned in subsection 1A. Those things are to understand the nature of D's conduct, to form a rational judgment, to exercise self-control.
Excuse me, I'm going to stop you there. 52 applies to diminished responsibility. It has never been part of the argument at trial or the grounds for appeal that this was a diminished responsibility case or plea. That the fact, as you allege, that there may be some abnormality, you would need to construct and couch that abnormality, whatever it is, around the sections that are relevant to loss of self-control. I mean, are you going to do that? This is taking us in another direction, and this is outside the remit of what we can develop in this court.
Could I have a few moments to confirm?
Yes, it's not, can you see it's not a diminished responsibility plea?
Indeed.
But abnormality, you may develop that later around if you were going to develop the fear point. And battered women.
Could I just have a few minutes?
Yes. I don't think you've got a few minutes, but you can take a few minutes.
My lady, I would refer to another, even though it's not part of my legal authorities and not legally binding in this court, I could refer to Law Commission report to enhancement of public learning.
Yes, I'm satisfied with the Law Commission reports.
If you could go to Orange tab 8, page 79.
Yes, thank you.
My lady, this report provides a perfect example of losing the ability to form a rational judgment in relevancy to the case at hand. I quote, "A woman suffering from post-traumatic stress disorder, consequent upon violent abuse suffered at her husband's hands, comes to believe that only burning her husband to death will rid the world of his sins.
I'll take that one.
My lady, as the statute above reflects that at the time of this incident, Mrs. Smart was suffering from an abnormality of mental functioning, and as such was impaired from forming rational judgment due to the violent physical and sexual abuse she suffered at the hands of her husband. My lady, have any questions?
Yes, if we look to the second ground of appeal, or perhaps I'll read it, I don't think anybody else has, to the second ground of appeal, that the judge misdirected the jury when he said that fear must be objectively construed and judged on what circumstances would place a reasonable person in fear, not what might or would place the defendant in fear, and he said he did not think much of this battered woman syndrome thing. So apparently that was the judge's direction on part of the law to the jury. And my question to you is, how relevant is what you've said about abnormality of mind to the last stanza that he did not think much of this battered woman syndrome thing?
I believe my next part of the submission could deal with the fact. My lady, I now submit the final point of my submission. Battered woman syndrome is a legally recognized cause for persons suffering from diminished responsibility. I refer, my lady, to the case of the Crown and Al-Huwalia, ex parte Curanjit, 1992, Volume 4, All England Reports, page 889, found on blue tab number 5, page 66. Does my lady require a brief summary of the facts of the case?
No.
My lady, I quote the trial judge, Lord Court Justice Taylor. I quote, Mr. Robertson submits that this appellant was suffering from a battered woman syndrome, such that it had become a characteristic within the means of Lord Diplock's formulation, that course of ill treatment had affected her personality so as to produce a state of learned helplessness, a phrase used by experts who have identified this condition.
So Mr. Robertson's submission on behalf of Mrs. Al-Huwalia was that it fell within Lord Diplock's definition. Lord Diplock's definition, of course, is the case of Campden, and in that context, the reference is specifically to provocation. Your reference is, you continually refer to diminished responsibility. I accept that in the case of Al-Huwalia, on appeal, on retrial, it was battered woman syndrome was accepted as part of the defence of diminished responsibility.
Indeed.
But the court, Lord Taylor said, in the appeal court, that it could be a characteristic which would also be applicable in the case of provocation. It seems to me that the argument here that I must hear from you is how does this assist us in understanding the section of the Coroners and Justice Act? I've heard from senior counsel who hasn't been too inclined to develop argument around the first section, which deals with fear as the qualifying trigger. Your submission now to the court is whatever abnormality the appellant may or may not have been or is suffering from, it's a condition that we must look at under diminished responsibility. So I'd like you to kind of rehabilitate your argument, because it's not, as I've said, it's not a matter of diminished responsibility. It's a matter of whether this abnormality that you talk of is relevant to fear, and whether the judge in the second ground, fear must be objectively construed, whether he was correct or not, and whether he was correct or not to have, it's not for me to say, but to have issued, I'll use that word, the battered woman syndrome thing, as he put it. Can you help me with
Indeed, my lady, I
that
believe,
a little bit more tightly?
Indeed, my lady, I believe due to the fact that the fear and the abuse that she struggled with due to the husband, it put her in such a state that she was not able to control her actions or form any rational thoughts at the moment. Does that satisfy your question?
Not entirely. are you then submitting to the court, differently from senior counsel, that the inability to rationally think on the matter is something that should be looked at around the fear defence?
Indeed.
So you are saying that that's the place for this kind of argument?
Could you repeat your question? My apologies.
Well, the senior counsel has argued on the second limb of the loss of self-control defence, and the first limb is a fear defence. So the qualifying trigger has only to be fear of serious violence.
Indeed.
I'll have to speak to my chief clerk about these phones going on in my court. To return to my point, you have submitted to this court an argument around an abnormality of mind, and you have submitted to this court the argument around diminished responsibility. This case is not a case of diminished responsibility. This case is, if it is anything, this appeal is whether there was a loss of self-control and whether that self-control was a matter of having fear as the trigger. So I'm trying to get from you whether your arguments are coming couched around fear, or whether you are going to continue to stand firm that it's a matter of loss of self-control due to extremely grave circumstances, which are the violent circumstances that you've described.
Due to the fact that she was in fact a battered woman, and the fear that she was going to suffer more abuse in the morning, we are arguing that fear was the trigger in this case.
Well, that's my question. So would all this abnormality locate around the issue of fear? That's what
Indeed,
I'm
my
asking.
lady. Due to the fear she felt, she was not able to form any rational thoughts at the moment, which led to the abnormality of the mind.
So you asked that's what you're not saying it because I'm trying to take you down that path. It seems to me that that's what you're wanting to say. Are you wanting to say that? It must be your submission, not mine.
It's my submission.
Yes, all right.
If I may, my lady, I'll just give you my conclusion.
Yes, thank you.
My lady, in conclusion, we submit to the court that due to the years of threats, physical and sexual abuse she suffered at the hands of her own husband, she suffered from a slow burn loss of control, and knew if she ever faced with such threats, fear, pain and humiliation again, she could lose the ability to form rational judgment or self-control. My lady, battered woman syndrome, as part of diminished responsibility, is intended to benefit women who have suffered as Mrs. Smart has suffered all 3 years. We, the appellants, respectfully invite you to allow the appeal on both grounds and order retrial for Mrs. Smart, where a jury may be properly directed and find her guilty of voluntary manslaughter, not cold-blooded murder. My lady, if my lady has no further questions for me, I'll conclude.
Well, I do have a further question. And the further question is that the second ground says that, and you have drafted the second ground, that the judge misdirected the jury when he said that fear must be objectively construed and judged on what circumstances would place a reasonable person in fear, not what might or would place the defendant in fear. I mean, that's the ground that you've drafted, isn't it?
Indeed.
So how should I approach fear? Must it be objectively construed? Was the judge wrong? I mean, you have said that.
Indeed, my
In
lady.
your written grounds, that's what you've said.
Indeed, my lady, the judge did in fact misdirect the jury.
And what do you say about your written ground? And said, this is at the judge, he did not think much of this battered woman syndrome thing.
My lady, due to the case I submitted clearly showed that battered women syndrome is accepted in English law.
Thank you very much. Thank you very much. Thank you, Ms. Shah, when you're ready.
May it please your ladyship, my name is Nasreen Shah, and I appear as junior counsel representing the respondent. If my lady has no further questions, I shall proceed with my submission. My lady, I have two submissions to make. First of all, the appellant, Mildred Smart, acted consciously with premeditation despite the past event. My second submission is that a battered woman syndrome implying abnormality of mind should not impact the murder sentence on the grounds that Mildred Smart was found sound of mind, conscious about the consequences of her act, and there is no such medical evidence that she could have in fact suffered of such syndrome. An assumption may not be enough.
Can I stop you there? Do we need medical evidence here? And has anybody mentioned a syndrome? Yes, battered woman syndrome, indeed.
Yes.
It's not, yes.
My lady, if I may explain, I would like to refer to medical evidence in order to explain battered woman syndrome and how it cannot necessarily in full capacity apply to the actions by Mildred Smart.
Thank you.
My lady, by referring to the case of the Crown and Kirajit Aluvalia, 1993, Volume 96, Criminal Appeal Reports, page 133, which my lady will find under Pink Tab 2, page 5. The element of premeditation can be found in a quote by Lord Taylor and can be applied in context. Is my lady acquainted with the facts of the case? I quote my lady, Lord Taylor. Bear in mind, it is a sudden and temporary loss of control for which you are looking, not a thought-out plan how to punish him for his wickedness. In the context at hand, it can be said that Mildred Smart had the intention to kill her husband, to punish him for all he had done to her. It is evident that Mildred Smart, in a police interview after the event, stated that she killed her husband because he deserved it, which proves that the appellant was conscious about her action leading to the death of another, and furthermore describes the wickedness of her action. She wanted him dead in order to punish him. Also, the appellant told her counselor that if her husband would ever hurt her again, she would kill him. By doing so, she proves the intention and underlines the wickedness of this crime. She sought revenge, as my learned friend Senior submitted, and thus this constitutes murder.
Can I stop you there, Ms. Shah? Again, I said this as well, I think, to your senior counsel, that we don't really want a total retrial on the facts here. But on what basis, having said that, I'm going to ask you on what basis are you sure, or can this court be sure, that when she said to her counsellor the words that you have just read out to the court, that those were words that she meant it and she intended it, and that they were not just figures of speech? I say frequently, if you don't do the washing up, I shall kill you. Do you get my point?
Yes, my lady. We believe, though, that due to the abuse she suffered and due to the past events, being a battered woman, which I will follow up in my submission, that it cannot be said that she would have meant it in another way other than literally, because a woman suffering from such pain, emotional distress and physical distress would react, in my opinion, to another attack. That's why, my lady, I think it is relevant, and that's why I try to make my point that she acted with premeditation by stating several times that she would actually commit this crime.
Or are you saying that that's one of a number of factors which, taken all together, form the background circumstances and the factual matrix which point to the argument that you are putting?
Yes, my lady. My lady, If you don't have any other questions, I would like to follow up with my submission to further explain my point. My lady, the case of the Crown and Fenton 1975, volume 61, Criminal Appeal Reports, page 261, illustrates that an abnormality of mind on the ground of voluntary intoxication cannot be accepted, and those effects should be disregarded. My lady, I feel this is important to explain the circumstances and the facts leading to my following submission. So if my lady doesn't have any further question.
Well, I really don't know where this point's going. I mean, I'm just waiting
Yeah.
to hear from you where this voluntary intoxication, of what relevance this is.
The relevance is concerning the normality of mind to support my that there's no medical evidence leading up later to battered woman syndrome, just to tackle the different grounds which could have applied in her situation but should be nevertheless disregarded, and that the judge...
I don't think this is helping me at all, Ms.
Okay,
Shah. Can you move on to your next point, please?
Of course, my lady. My lady, in the case of the Crown and Codere, 1916, volume 12, Criminal Appeal Reports, page 21, we intend to illustrate why a defense of battered woman syndrome or abnormality of mind in the instant case of Mildred Smart does not apply. My lady, Lord reading on the mentioning of the McNaughton rules, I quote my lady, if the accused does know either that this act is morally wrong, according to the ordinary standard adopted by the reasonable man, or that it is legally wrong, then it cannot be said that he does not know what he was doing, what was wrong. My lady, you can find the case under blue tab 4, page 4. In the context at hand, Mildred Smart arose herself from her daze, in full recollection that 2 hours later her husband was still asleep in a drunken state, unconscious. She recollects the events in precise detail, from proceeding to walk downstairs, which in itself implies that she was clearly in a state to think, then pours herself a large glass of whiskey, going to the embroidery box to retrieve scissors to go ahead to kill her husband. Also, the fact that Mildred crept upstairs clearly highlights her determination and her premeditated intention to kill her husband. During the course of these events, the appellant had enough time to reconsider her actions, and thus it is clear in relation to Lord Reading's quote from the case of the Crown and Codere that Mildred Smart had full capacity of knowing what she was doing.
I'm not going to accept the Codere point, I'm afraid, Ms. Shah. I don't think that that's relevant, nor McNaughton. You have said to this court that you are going to develop the argument around battered woman syndrome, and I'm yet to hear from you how you are going to do this. I don't think the authorities that you've quoted are going to help you. And I'm hoping that at some point it will lead to you rehabilitating Mr. Andrews in his final passage, where he said that in fact the judge's direction to the jury was indeed a misdirection. So I do hope that you will allow enough time in your submission to deal with that.
My lady, we were using the case to explain in further context why she acted this way, and that battered woman syndrome cannot apply if my lady, still disregarding case, would like to hear my further submission.
So you're saying that, but what you are saying, to use the word colloquially, you're saying that in fact the appellant is mad. Is that what you're saying?
No, my lady.
No. Right. But you're saying she didn't suffer from battered woman syndrome.
We are trying to establish that despite the way she was treated and the events of the past, that this should not have impact on the actions in the present, that despite her, which we don't deny, being a battered woman, should not be relevant as to her mind. She was clear of mind enough to make all of these decisions, following up and remembering each and every one of them. So she had the choice to leave or seek help, but she didn't. She chose to kill her husband. And this is what I would like to further elaborate with my submission.
Yes, well, please do. Less of the coterie, please.
It follows that any defense proclaiming abnormality of mind due to a possible yet not factual medical issue in the case, the case of the appellant should be considered invalid. The argument that Mildred was acting with her senses is further illustrated by the fact that she was acting in pursuit of revenge, as my learned senior illustrated before. And it is clear from the fact that Mildred had considered murdering her husband before the actual event. As mentioned earlier, a statement made by her counselor illustrates that she would have killed her husband if he'd ever hurt her again. It is also evident that she admitted killing Sam because, I quote, he deserved it. My lady, we feel that Mildred Smart was in full capacity and sound of mind, and despite personal sympathy for the appellant, it cannot be said that her actions constitute less than murder. And my lady, it is for those reasons and those given by my learned senior that nevertheless I urge my lady to uphold the murder conviction. And if my lady has no further questions, I will conclude my submission.
Well, I do have a further question, and that is that Mr. Andrews said in his concluding remarks that, in fact, the learned judge did misdirect the jury.
Yes, my lady. I think my lady...
I can check that with our stenographer here. Stenographer.
Yeah.
Yes, you can check it. It's on the record.
I think my learned senior was referring to the first ground, but I am referring in total and to the second ground, constituting that my learned senior was wrong, my lady, and the judge
your learned senior was wrong on the first ground. So you have a difference of opinion.
No, my learned senior would like to overturn what he said before.
Would like to correct himself,
yes.
would he? So could you do that for him? In summary, so you are saying on both grounds, what are you saying?
My lady, we're saying that the judge didn't misdirect the jury, that considering all the circumstances and the facts of the case, Mildred Smart, although a battered woman and in need of help, could have sought help, but she decided to commit a crime, and that the judgment was fair and just and should be considered and not overturned.
Thank you very much, Ms. Shah. Thank you very much. All rise. Please be seated. I propose in this case to deliver my judgment on this appeal, and then in conclusion of my judgment I will make some very brief comments on the two teams this evening. When a person dies, it is always a terrible thing, and we do not take the death of a man, nor the death of this man, lightly. To take the life of another is a very serious thing, and we must never, ever consider this matter with anything less than reverence for human life, whatever the character and conduct of the departed. A family will have lost their son, and a wife, the appellant, has lost her husband, and she must bear the responsibility for killing him for the rest of her life. The deceased was killed following an episode of violence directed at the appellant by a single stab wound, puncturing the heart, causing almost instantaneous death. The appellant immediately phoned the emergency services and has cooperated with the prosecution fully throughout the duration of this case. This appeal has been greatly assisted by counsel for the appellant, Mr. Charles Hogan and Mr. Mohamed Shahid, and for the Crown, Mr. Andrews and Miss Shah. And I'm very grateful to both of the appellant and for the respondent, both counsels, for their submissions this afternoon. I turn to the law. The law has now been framed to include fear as a qualifying trigger, when in the past anger was the only ground. The Coroners and Justice Act section 54.3 has dealt with what was formerly considered to be a lacuna in the law, and some would say resulted in gender bias. Indeed, that limitation in the law has been critiqued by this court in a number of cases, and also by the House of Lords, and also by the Privy Council. In this court, the late Chief Justice Lord Peter Taylor, in the case of the Crown against Ahluwalia, and we've heard submissions this afternoon on that case, accepted the expansion of the law on provocation as it then was, recognised that the battered woman may indeed react differently and may be boiling over, simmering, under cumulative provocation, and he ordered a retrial. The House of Lords in the case of Smith Morgan 2000, and we did not hear argument on this case this afternoon, especially Lord Hoffman, in an extensive consideration of the history of provocation, raised his concern with the genderedness of the law when he spoke of male proprietorialness continuing to be a ground for provocation. And also the Privy Council in the case of Attorney General versus Holly returned to the problems inherent in the past law. There was much jostling, if I may put it, by counsel and indeed judges who were painfully aware of the inadequacy of the law as it then was, and so in trying to do justice, judges accepted counsel's attempts to plead cumulative provocation and expanded the law. Lord Steyn, in the case of Locke in 1996, very much pronounced that the law should not be led by the dictates of logic, but by the dictates of justice. In this charade, the objective of the courts was to do justice rather than law. I am, too, very much of that persuasion. However, doing justice lies at the heart of the criminal justice system, as does doing law. Indeed, Lord Steyn summarised the moral predicament when he said that it was the purpose of the courts to work out sensible and just solutions. So I now turn to the predicament of spousal homicide. In reviewing the law on provocation and the cases involving women who killed violent partners, as indeed in this appeal, as Professor Susan Edwards has shown in her excellent researches, and I quote from these obiter, about 100 men each year kill female intimates and about 20 women kill male intimate partners. And of those 20, the majority are killing violent perpetrators, literally, though not always legally, in self-defense. Women killing violent partners face murder convictions, as did Mrs. Alawalia, as did Mrs. Thornton, albeit that in both cases their convictions were quashed on appeal. It is also clear that in many cases, many women who were in fear were faced with having to plead diminished responsibility, as pleading provocation presented with the obstacle, especially the requirement of immediacy. The very sad case of Sanger, 1987, is such a case. Were it not for the immediacy problem of the defence of provocation, she would have better fitted her circumstances into a defence of provocation than the defence of diminished responsibility is pleaded. This now brings me on to the current law. What the law must do is steer a clear line between battered women who kill out of a considered desire for revenge and those women who kill out of fear. And we've heard much this afternoon on that particular point, especially from counsel for the Crown. The law certainly provides for that distinction in the precise words of the current statute. The law has also removed the proximity and time requirement. However, whilst it may no longer be a requirement, it still remains a consideration. And indeed, that point was forcibly made by counsel for the respondents this afternoon. In addition, the course of conduct that was excluded by Justice Devlin in the case of Duffy in 1949, upon which the whole edifice of the former law of provocation rested, is now a vital consideration when looking to evidence of the deceased's violent conduct and the defendant's response through fear to the anticipation of it. And we've heard this afternoon from counsel for the appellant, especially on that particular point. And so the Coroners and Justice Act accommodates now the fearful battered woman, but it does not do so willy-nilly, if I may use that phrase. Fear is only established where a set of criteria are operative. In this case, the courts are entitled to define whether the defendant was in a state of fear. They may call on expert evidence, and we did have some limited, albeit limited, reference to expert evidence in the rebuttal that we heard from the respondents. Call on expert evidence to assist them, and it is a matter for the jury to determine whether or not a defendant passes the litmus test or plimsoll line of fear or being in a state of fear. But fear of serious violence, and therefore evidence of the previous violent conduct of the deceased, is critical. In this court today, fear is not only present in relationships where the woman defendant is timorous and passive, but a robust woman may also be in a state of fear. It has been pointed out by counsel that the state of thinking and understanding on fear draws not only from research, but also from knowledge of battered woman syndrome. Regrettably, I wasn't particularly assisted, as I hoped that I might be, on the definition of battered woman syndrome and the wide application that it has enjoyed, particularly in the United States and Canada. And I might just take a moment to say something further on that a little bit later in my judgment. It has, however, been pointed out by counsel this afternoon that the syndrome does not only denote a psychiatric condition, but it has been pointed out by counsel that perhaps it more satisfactorily aligns with insanity. I have to say that I rejected that when I heard those submissions, and I rejected the basis upon which that argument was made. I would, in my judgment on that point, draw your attention to the fact that battered woman syndrome, or the condition of being battered, denotes also a behavioural condition, and perhaps it's better to speak of the effects of battering or abuse and how they may put pressure on a particular individual and create a series of psychological symptomatology rather than a psychiatric one, but certainly not the arguments that were hedged around the Codery case. I'm also mindful that I've heard from both counsel on the issue around the killing of a sleeping man, and particularly the delayed response of the appellant in the 2-hour delay between the last act of violence and then the act that caused the death of the deceased. And my remarks on much of what I'm going to say now are to be treated as obiter, because I haven't heard fully arguments around the predicament of those who kill a sleeping man. I heard instead arguments around the delay in the last act, violent act, and the act of retaliation. So I draw on the jurisprudence from America on this point. I do so because America has considerable experience of battered women who kill, and the courts across the US are presented with about 2,000 cases of this sort that we've heard this afternoon on an annual basis. In Stewart, the Kansas Supreme Court held that the jury was not entitled to an instruction on self-defense, as the appellant was not in imminent danger when she shot her sleeping husband. And the majority ruled that under such circumstances, a battered woman cannot reasonably fear imminent life-threatening danger from her sleeping spouse. We did hear some arguments, particularly from the respondents, about whether it was reasonable for the appellant to have acted in this particular way. But again, I do stress that the arguments that I heard were couched around the time delay and not necessarily around the point that he was in fact a sleeping man. Returning to the American jurisprudence, again, the imminence requirement provided a stumbling block in the case of Norman. The North Carolina Supreme Court held that because there was no action underway immediately prior to when the deceased fell asleep, the defendant had ample time and opportunity to resort to other means of preventing further abuse by her husband. And we did hear this, particularly from junior counsel for the respondent, that there were other things that the appellant could have done in a situation in which she found herself. But the narrow interpretation of imminence required served to exclude from consideration much of the violence, fear and abuse which had been endured, as well as any efforts to escape. I have referred to some of the American jurisprudence, but returning back to the Coroners and Justice Act, I wish to emphasise the fact that we are no longer here tethered by an imminence requirement that is stated in the statute, that a time delay is no longer a vital component before one can avail oneself of a defence of loss of control under either the fear or indeed under the second trigger, which is circumstances of grave character. And therefore, in looking at a sleeping man, as was this case, and looking at the 2-hour time delay, as was this case, the context must be examined, and in my judgment, the time of 2 hours is of little relevance. In dealing with the time element in respect of looking to whether it was a considered desire for revenge, which is also the purpose of the statute, to draw a distinction between cases where there has been a time lapse and the actions have been deliberate and intentional, and in cases where there's been a time lapse and there has not, statute has introduced this phrase of a considered desire for revenge. I have heard this afternoon that in fact, again from the respondents, that there was a considered desire for revenge in this case. However, I've not heard before me from either counsel sufficient in respect of the condition of battered woman syndrome. So there are a few remarks that I would like to add on that. I would, in just concluding my remarks on time, we did hear that time functioned to suggest intention. Had the arguments around battered woman syndrome been better developed by either teams, we would then have been more, I would then, the court would then have been more able to conclude that the delay in time could also be explained by post-traumatic stress disorder, shock, and the various symptomatology that characterises battered women either as a psychiatric condition or as a behavioural condition. Unfortunately, this court was not assisted by developing the jurisprudence on those very important considerations. I would also add that on the matter of fear, perhaps the question was not developed sufficiently to help this court, because the view was held that there were insufficient cases and precedent on that point. I did hear from both sides on the case of Alawalia. So at this point I'd like to refer to the United States jurisprudence. Again, because of the volume of cases that they've been presented with, they are better enabled to discourse about fear and battered woman syndrome. I would first of all refer to the case of R, the Crown versus Laverly. This is actually a Canadian case, and in this case it's 1990, and here Madam Justice Wilson, giving judgment for the majority, allowed expert testimony on why she did not leave the relationship, and Madam Justice Wilson focused on the testimony's potential to explain the woman's reasonable apprehension of death or grievous bodily harm, as well as the reasonableness of her belief that killing was the only way to save her life. In many ways, this does have some similarity with the passage that was quoted to me from the Law Commission, and I think it might have been useful if that passage from the Law Commission had been buttressed with this passage from Laverly. It has also been pointed out by counsel that drinking of alcohol and involuntary intoxication might have been a relevant point. I rejected that point of being no relevance in this case. Finally, as I draw near to my conclusion, I also have to consider the method of killing and the cause of death. In this case, the defendant killed the deceased with a knife, and on this point there is considerable public policy concern about the use of such weapons, which are certainly becoming a scourge and a threat to life in our society. However, in this case we must look at the context of the use of this knife. This was not a case of Agatha Christie's Murder on the Orient Express, where a number of parties inflicted several stab wounds on the body of the deceased. This was not a case of multiple stab wounds, nor was this a case of stab wounds inflicted with any such ferocity, but perhaps from the force used and the frequency of wounds one might be able to infer the degree of intent. In this case, the method of killing and cause of death was one single stab wound to the chest. It was a feeble effort, and were it not for the fact of the position of the knife as it entered the body, it would not have resulted in death. Unfortunately for the deceased and for the defendant, the knife nicked the ventricle and caused such an outpouring of blood that the deceased literally bled to death. I have to consider this too when assessing all the factors. As to the other circumstances, I've been asked by counsel to consider other factors like the moral backcloth and the character of the defendant. As for the character of the deceased, it might be said that we should not speak ill of the dead, and because he cannot defend himself, then if you cannot speak well of a man, perhaps we should not speak ill. But the fact is also that many might say he had only brought it upon himself. He was, by his actions over a long period of time, and it's not been disputed by either counsel for the respondent, and it has been advanced by counsel for the appellant that he was a vicious and violent brute who repeatedly terrorised his wife and kept her literally sub virgo. Nonetheless, women kept in these conditions are not entitled to kill, even if by doing so their pain and suffering may be ended. Now finally to the two grounds for appeal. As to the first ground, the learned judge said that the defence of fear required evidence of violence endangering life and nothing short of it. In my reading of the statute does not say that, it says evidence of serious violence, and this was formed part of the submission on behalf of the appellants. The appellants made some minimalistic reference when probed by me to help this court understand what is serious violence. And I would say that the direction may have misled the jury as to the Plimsoll test for fear. Regrettably, I didn't hear sufficient from either counsel for the appellant or counsel for the respondents on the ground of fear. In fact, on the contrary, for the appellant, who had drafted both grounds of the appeal, counsel for the appellant told me in this court that he was going to proceed on the second limb of the act and not the first, and therefore disregarding his first ground that he had drafted on paper. So I would say that I was not assisted with the arguments on the fear ground. As for the respondents, again, they seemed to avoid any full discussion of that and preferred to address this court on matters relating to insanity and to diminished responsibility, which were neither the subject of the trial at first instance, and they did not form the basis of any of the ground for appeal. So I didn't glean any help from their submissions on that point. The learned judge also said that the loss of self-control required a reflexive trigger. After probing the counsel for the appellants, I was finally to be advised that, in fact, loss of self-control does not require a reflexive trigger, and that it's part of the statute that a delay is permissible in certain circumstances, and that this fell into those circumstances. On this point, it's true to say that the conventional nomenclature used in such cases has been crafted around seeing red, explosive volcanic loss of self-control. But we do now accept in both Ahluwalia and in the case of Thornton, in the latter I was not referred to that case, that the external manifestation of loss of self-control may inhabit less of the explosion and more of a slow burning fuse. Some of that argument was, I think, implied in what the appellant's case and how they submitted it to me this afternoon. These cases of Ahluwalia and Thornton have paved the way for challenging the orthodoxy, and in addition we know, although it's not been argued here by either appellant or respondent's counsel, that fear may sap the ability, may cause tears, as we saw in this case, may cause symptoms of post-traumatic stress disorder, may cause behavioural symptoms, and may result in a different kind of loss of self-control, but a loss of self-control nonetheless. As to the second ground, I would say that the judge has said fear must be objectively construed. This is where the expert witness is of great value, to equate the jury with the predicament of the battered woman and explain to the jury that her fear is the fear of a reasonable battered woman. I did ask counsel whether the argument of fear was fear of a reasonable woman or fear of a reasonable battered woman. I was told that the fear equated with the fear of a reasonable person. I'm not sure that I totally agree with that line of argument. In my submission, it must be fear of a reasonable battered woman, a woman who's trapped in a battering relationship, and not fear of a reasonable person that might apply to a woman who would be in a happy relationship with a loving and caring husband who has no reason to fear his face at the window, or hear the sound of the front door keys in the door, or hear the car driving up the drive, because the happy woman knows that all will be well. The woman in fear of violence knows that it will not. I'm very grateful to the arguments, as I have already said, that have been presented by counsel for the appellants and the appellant and counsel for the respondent. I have come to the conclusion in assessing both teams then, and a brief word on the teams and on each of the submissions this afternoon. If I can deal in this way with the senior and junior counsel for the appellant first and the senior and junior counsel for the respondent. The senior counsel for the respondent was Mr. Hogan. He dealt very well and confidently, I think you will agree, with the questions that were put almost throughout the duration of his submission that he made. He was never destabilised from his core argument, and he stuck to the questions that were put to him in a very robust way. However, my main criticism that you've heard already of Mr. Hogan's submission was that he decided halfway through that he wouldn't deal with the first ground, which was the main ground of the whole of this appeal, the fear defence, and he would deal with the second limb of loss of self-control manslaughter, which relies on circumstances of extremely grave character. Perhaps he'll tell me afterwards why he decided on this rather strange strategy, which I did point out at the beginning. The junior counsel then was Mr. Shahid. Again, I think Mr. Shahid dealt very well with the questioning that he had to endure from the judge. And I think that he responded very well. And what was very impressive, I think, from all counsel this afternoon is that nobody dried up. You kept going, and you very much kept to your arguments, whether your arguments were the right ones. I'll say a bit more about that. And Mr. Shahid's argument, he was determined that this was a case of diminished responsibility, which this was not, and his authorities for those, and the language he used, returned us to diminished responsibility when I probed him on the abnormality of mind, from which he said the appellant had suffered. If I turn now to the respondents, Mr. Andrew, senior counsel to the respondent, again, replied very robustly and was very good in his responses to the interventions by the judge, which again were many. However, I was not persuaded by some of his use of the legal argument. Self-defence, I think that took us somewhere where we didn't need to go. And of course, you well know what was fatal to your argument, and perhaps don't want it ever to be mentioned again. Perhaps in that respect we can all learn from when we are nervous and we keep going. Perhaps this is the time when we should stop and rethink, because your last phrase, it seemed that you were arguing for the appellant, which you withdrew later, and not for the respondents. Miss Shah did, at the end, I kept persuading her, would you please rehabilitate Mr. Andrews' last closing remarks. But let's go to Miss Shah again. I think that you responded very well to the judge, who kept going. But I think that, again, it would have been to your advantage if you concentrated on battered woman syndrome. You went down the road of insanity, and we heard about McNaughton. And maybe if you had crafted it a bit more tightly, to have said why it wasn't insanity, but the way in which it was crafted led me to believe that perhaps you needed to revisit the law. Can I say everybody did absolutely excellently. You did very, very well indeed. Really, it's so close. It's very, very difficult to actually find anybody who was slightly better, and that's all, slightly better than any of the others. And I am going to say that I felt Mr. Hogan was the best presenter of this afternoon. But I do want to underscore this with the fact that it was so close that you have won by a hair and no more. Can I thank you very, very much for the time you've put into this week in term, when you've got all the other preparations. You did very, very well indeed. Thank you, and to everybody else who's attended. I'm sure perhaps Justin might want to say something, especially to the Dean, who's had a brilliant day, and to other members of staff, but especially to the Dean, who has been in everything that's been going on today. Thank you very much, and just keep going, every one of you. I've enjoyed it. I'm sure you've all enjoyed the ordeal. And you get to a point sometime down your career where you are actually enjoying it more than it being, there's more pleasure in it than pain.